Indian Arbitration and Consultation Act, 1996. Introduction. The Indian Arbitration and Conciliation Act of 1996 marks a pivotal moment in India's legal landscape, providing a modern and comprehensive framework for the resolution of commercial disputes. This legislation not only aligns with international standards, but also serves as a catalyst for promoting arbitration and conciliation as preferred modes of dispute resolution. This detailed note aims to delve into the salient features of the Indian Arbitration and Conciliation Act, 1996, exploring its key provisions, significance, and impact on the Indian legal system. Key provisions of the Indian Arbitration and Conciliation Act, 1996. Arbitration Agreement. Section 7. The Act defines an arbitration agreement as an agreement between parties to submit present or future disputes to arbitration. It outlines the requirements for a valid arbitration agreement, emphasizing the need for it to be in writing. Appointment of arbitrators. Sections 11 to 15. The Act provides a mechanism for the appointment of arbitrators. If the parties fail to agree on the appointment, the Act empowers the Chief Justice or any person or institution designated by him to make the appointment. The Act also specifies the grounds for challenging the appointment of an arbitrator. Interim measures by courts. Section 9. Recognizing the need for interim relief, Section 9 empowers the courts to grant interim measures, such as injunctions, to protect the rights of parties during the arbitration process. This provision ensures the effectiveness and enforceability of the arbitral process. Conduct of arbitral proceedings. Sections 18 to 27. The Act establishes the framework for the conduct of arbitral proceedings, including the language to be used, statements of claim and defense, and the right to be heard. It empowers the tribunal to determine the admissibility, relevance, and weight of evidence. Conduct of arbitral proceedings. Sections 18 to 27. The Act establishes the framework for the conduct of arbitral proceedings, including the language to be used, statements of claim and defense, and the right to be heard. It empowers the tribunal to determine the admissibility, relevance, and weight of evidence. Making of award and termination of proceedings. Sections 28 to 33. The Act delineates the process for making arbitral awards, emphasizing that the award must be in writing, signed, and state the reasons upon which it is based. It also outlines the grounds for challenging an award and the procedure for termination of arbitral proceedings. Setting aside of award. Section 34. Section 34 provides the grounds on which an arbitral award can be set aside by a court. This includes instances where the award is in conflict with the public policy of India or the subject matter is not capable of arbitration under Indian law. Recognition and enforcement of awards. Sections 35 to 36. The Act recognizes the finality and enforceability of arbitral awards. Section 35 deals with the finality of arbitral awards, while Section 36 empowers a party to apply to the court for the enforcement of the award. Conciliation. Sections 61 to 81. The Act incorporates provisions for conciliation as an alternative dispute resolution mechanism. It outlines the process of conciliation, the role of the conciliator, and the enforceability of settlement agreements. Salient features of the Indian Arbitration and Conciliation Act, 1996. Scope and applicability. The Act applies to both domestic and international arbitration, reflecting India's commitment to providing a unified legal framework for dispute resolution. It covers a broad spectrum of disputes, including those arising out of legal relationships, whether contractual or not. Arbitral tribunals. The Act provides for the establishment of arbitral tribunals to resolve disputes. The composition, jurisdiction, and powers of these tribunals are clearly defined. Parties have the autonomy to determine the number of arbitrators, and in case of disagreement, default provisions apply. Appointment of arbitrators. The Act introduces a streamlined process for the appointment of arbitrators, emphasizing the principle of party autonomy. In the absence of agreement between the parties, the Act empowers the Chief Justice or any person or institution designated by him to appoint arbitrators. Conduct of arbitral proceedings. Arbitral tribunals are granted wide discretion in conducting proceedings, ensuring flexibility and efficiency. The Act provides a framework for the tribunal to determine the admissibility, relevance, and weight of evidence, fostering a more adaptive and responsive approach, court assistance and minimal judicial intervention. The Act adopts a pro-arbitration stance, minimizing judicial intervention in arbitral proceedings. The role of courts is mainly supportive, limited to assisting in the appointment of arbitrators, enforcing interim measures, and facilitating the arbitral process. Challenge and recourse mechanisms. The Act provides a clear and limited framework for challenging arbitral awards, contributing to the expeditious resolution of disputes. The grounds for setting aside an award under Section 34 are exhaustively listed, curbing the scope for prolonged litigation. Conciliation and mediation. The Act incorporates provisions for conciliation and mediation, offering parties alternative avenues for resolving disputes. It outlines the role of the conciliator or mediator, and establishes a legal framework for the enforcement of settlement agreements arising from such processes, interim measures and emergency arbitrators. The Act empowers arbitral tribunals to grant interim measures, providing parties with effective remedies during the pendency of the arbitration. The 2015 amendment introduced the concept of emergency arbitrators, allowing parties to seek urgent relief before the constitution of the arbitral tribunal. Enforcement of awards. The Act establishes a streamlined process for the enforcement of arbitral awards, both domestic and foreign, contributing to the finality and enforceability of arbitration outcomes. The grounds for challenging an award are limited, aligning with international best practices and promoting a pro-enforcement approach. Neutrality and independence of arbitrators. The Act emphasizes the neutrality and independence of arbitrators, ensuring a fair and unbiased resolution process. Arbitrators are required to disclose any circumstances that may raise doubts about their impartiality or independence. Significance of the salient features. The salient features of the Indian Arbitration and Conciliation Act, 1996, collectively contribute to the Act's significance and efficacy in shaping India's arbitration landscape. The Act's pro-arbitration stance, minimal judicial intervention, and adherence to international best practices have positioned India as an attractive hub for arbitration and dispute resolution. The significance of these features can be highlighted through examples of landmark cases, and the evolution of India as a preferred destination for arbitration. Conclusion. In conclusion, the Indian Arbitration and Conciliation Act, 1996, with its salient features, has played a transformative role in shaping the arbitration landscape in India. From promoting party autonomy to streamlining enforcement procedures, the Act reflects a forward-looking approach that aligns with global best practices. The significance of its features is evident in landmark decisions, legislative amendments, and the growing international recognition of India as a hub for arbitration. The Act's journey from its enactment to its subsequent amendments showcases India's commitment to fostering a conducive environment for alternative dispute resolution. As India continues to position itself on the global arbitration map, the Act's salient features will remain instrumental in shaping the country's trajectory toward becoming a preferred destination for resolving commercial disputes. Through a harmonious interplay of legislative reforms, judicial decisions, and institutional developments, the Act stands as a testament to India's commitment to fostering a robust and efficient arbitration ecosystem.